Hello viewers, in this lecture I will talk to you about the remaining two categories of void agreements which are prescribed in section 29 and section 30 of the Contract Act. I will first read section 29 and then will proceed. Section 29 of the Contract Act runs as under: agreements, the meaning of which is not certain, or capable of being made certain, are void. The meaning of this provision, friends, is very clear, and the reason is obvious. Go back to proposal and acceptance. It must be specific. Acceptance must be unconditional, as it is. And look at the definition of consideration, section 10. Taking the sense of all these provisions, one can say that essentially contract is entered into for the purpose of doing or not doing something. Now, if the situation is that you are not clear as to what to do or what not to do, in that situation, question arises: can it be said to be a contract which would be enforceable? The answer is clearly no. Law does not expect you to do uncertainty, the vagueness, ambiguousness. No, law doesn't give any room to all these situations. Contract is a very specific thing, and the terms of the contract must be clear as to what is to be done or what is not to be done. And therefore, the first part says that if it is not clear, it goes. If it is not capable of being made certain, again, at the first blush, it may happen that yes, terms are not clear. But on the close reading of the terms, it becomes clear that yes, what is to be done or what is not to be done can be made clear, can be made certain. In this situation, law says, yes, it would be enforceable. But if it cannot be even asserted or is not even capable of being asserted, then the section latter part says that it is void. I would give you two examples. Just simply place an order that 100 tons of oils. Now, is it that only one category of oil is available in the world? There are a number of types of oils. And therefore, you cannot make certain that which type of oil. In this situation, the agreement would be void because it is neither clear nor capable of being made clear. As against that, if you enter into agreement saying that I want to purchase all grains in your granary, yes, though it may not be again clear that which grains are there, but one is purchased to prepare, prepared to purchase the entire grain quantity lying in the granary. Thus, the section makes it clear that it is only the agreements, meaning of which is clear or can be made clear or capable of being made clear, is enforceable. Otherwise, it would be void. Now, we will go to section 30. I will first read the section, which is a bit lengthy, and then proceed further. Section 30 of the Contract Act runs like this. Agreements by way of wager are void. Inverted comma. Semicolon. And no suit shall be brought for recovering anything alleged to be won on any wager or entrusted to any person to abide the result of any game or other uncertain event on which any wager is made. Full stop. The second paragraph to the section says, this section shall not be deemed to render unlawful a subscription, or contribution or agreement to subscribe or contribute, made or entered into for or toward any plate, price, or sum of money, of the value or amount of 500 rupees or upwards, to be awarded to the winner or winner of any horse race. Full stop. The third sub-para says, nothing in this section shall be deemed to legalize any transaction connected with horse racing to which provisions of section 294A of the Indian Penal Code apply. Full stop. Pausing here for a moment, look at the situation. What is declared void? Wagering agreement, as it is colloquially termed. What is wager? In simple parlance, bet. Why? It is the situation, the happening or not happening of it is uncertain, and no party to the contract has either interest in this or has control over the happening or not happening of the event. In substance, you can say that it is mere chance of winning or losing by one party and the other party. In fact, there is no other stake involved in the contract except the winning or losing by the parties. The gambling. And therefore, it is essentially, you can say, that a public policy. Law doesn't want gambling, and therefore it is prohibited by declaring such transactions as void. The first paragraph of the section, after declaring the transaction as void, also clarifies that even collateral transaction dependent on the wagering agreement would also be void. Meaning thereby, if I have advanced you money for entering into wagering agreement for which you have executed promissory note, the main transaction being wagering contract is void. Can I file suit for recovery on the basis of promissory note? The answer is no in the second part of the section. The reason is that when the wagering agreements are declared to be void, the collateral transactions also must meet with the same fate. And therefore, no suit can lie for the recovery of money on the basis of promissory note, which was executed in return for borrowing for wagering agreement. But the subpara of the section protects the contribution made towards the award of prize, etc. in case of horse racing. At the same time, the second subpara says that if the things are contrary to section 294A of the Indian Penal Code, they do not stand legalized by this. Section 294A of the Indian Penal Code makes it an offence of ticketing at the racecourse house, with which we are right now not concerned. Here the important question arises that when we say that gambling is declared to be void, there are a number of transactions which as such resemble to this nature. First one, you can say the contract of insurance. Take the example of yearly insurance. You pay premium for 1 year for the accident which is not in your control, or even the other party's control. For that matter, under nobody's control, because it is an accident. But would it be a contract in the nature of wagering agreement and therefore void? The answer is no. Why? The reason is, though it resembles in certain aspects, the most important aspect present in the contract of insurance is the insurable interest. Each owner of the vehicle, say, has an insurable interest in protecting his vehicle. So, on this part, definitely it is different than the gambling agreement. Similar is the situation about crossword puzzle, games of skill, say like rummy. It has been held by the Supreme Court that rummy is a game of skill and therefore is not gambling. See, it all depends on the facts and circumstances, because you can bet on anything. The test is whether it is merely a chance that causes gain or loss to the parties, or it involves some skill, some effort, some knowledge. If it is so, law says it would not be a wagering agreement. It would be wagering agreement only when the happening or not happening is not within the control of the parties and the resultant effect is only gain or loss by some. So we may enter into agreement whether today it will rain or not. If it rains, I win. If it doesn't rain, you win. In that situation, yes, it would be hit by the provision of section 30. The reason is, as I have explained earlier. Therefore, any sort of wagering agreement, they are declared to be void. Similar is the situation in case of shares and stocks of the company. In one sense, you can say that yes, it is gambling. In fact, it moves every day so violently that even the talk of fever to someone also crashes the market. Maybe funny, but it's a reality. But then, the most important aspect is that there is delivery of shares and stocks in the physical state. Maybe the demat form, but there is. And therefore, it is not a gambling. Similar is the situation with lotteries. Lottery is definitely a game of chance. But certain states have legalized it, and therefore it may not be an offense under the Indian Penal Code. But simply because state has legalized it, it doesn't take away the character of being wagering agreement. Thank you. In the next lecture, we'll talk about quasi contracts.